For this lecture, we're going to be talking about who bears the risk in a real estate transaction. And we're going to discuss two issues that are related to risk. One is equitable conversion, and the second is caveat emptor, or buyer beware. So who bears the risk if something happens to the property during the purchase period? Is it the buyer or is it the seller? Well, under the doctrine of equitable conversion, the buyer is seen as the equitable owner of the property as soon as that purchase agreement is signed. So even though we may have a month or two before closing, the buyer and the buyer takes possession, the buyer is seen as the equitable owner. While the seller is then viewed as the equitable owner of the purchase price. It might seem a little weird to think of a purchase price as something that you could own, but you think about it, it is personal property, or at least the promise of personal property, because cash is considered personal property. So the seller is viewed as the owner of this personal property that's being exchanged for the real property. Now, that might not seem very fair to you, and you are not alone. So we're going to go into a case right now and try to unpack some of the reasons for this historic or common law approach. So we're going to discuss this case, Brush Grocery Cart Inc. v. Surefine Market Inc. Brush, they leased a commercial building from Surefine for a 5-year term. In that lease contract, there was an option to purchase the property. And Brush decided to go ahead and exercise their option to purchase. But Brush and Surefine could not agree on a purchase price. And so at the end of their lease term, Brush vacated the building, and then they sued Surefine in civil court in order to enforce their agreement, so to try to get specific performance. Well, during the litigation, there was a massive hailstorm that caused $60,000 worth of damage to the property. So the question arose, who should be liable for that cost, the cost of the hail damage? Should it be Brush or Shore? Right? Would it be the buyer or the seller? The trial court allocated this loss to Brush because they said that Brush was the equitable owner. The intermediate appellate court affirmed this decision. So the case in your book is the Colorado Supreme Court, and they reversed the appellate court's decision, and they held that it was Surefine, the seller, instead, that would be the ones who were going to bear the risk of the loss because they had the right to possess. And with the right to possess comes the risk of loss. In this case, the court discusses 3 approaches for allocating risk. The first approach was, as they put it, is followed by a slim majority of states. And it is the doctrine of conversion, and it's on page 553. They note how this approach places the risk of loss on the vendee from the moment the contract is entered into. And they point out that the rationale for this position is that once this equitable conversion takes place, then the vendee should be treated as an owner for all purposes. Now, the court points out that they don't quite agree with this because the buyer doesn't have one of the primary rights of ownership, which is possession, the present right of occupancy, or the right to control. So they look at a second approach, which is called the Massachusetts rule. And under the Massachusetts rule, the seller continues to bear the risk until there's actual transfer of title, absent an express agreement to the contrary, right? So with the Massachusetts rule, the seller would bear the risk until closing. But the court felt like this rule was a little bit too rigid. So they adopted a third position, which is that the risk would follow the right to possess. So if the buyer has the right to occupy and possess, then the buyer would bear the burden of the risk. If the seller had the right of possession at the time the loss occurred, then the seller would bear the risk. So what did that mean in the present case? Well, Bush did not have the right to possess. So since Brush didn't have the right to possess, and they did not bear the burden for the risk of loss. Sure, find it. Of these three approaches for allocating risks that were discussed, which do you think is the best? Well, the first approach has the advantage of being predictable, and it is the majority rule. So this is the first approach, as we discussed, was equitable conversion. If there are parties that are pretty sophisticated, they could plan for equitable conversion. But as the Brush Court pointed out, equitable conversion is a rule that is not very equitable, right? Because the buyer doesn't have the right to possess or occupy the property. So the seller could essentially commit waste on the property, and the buyer would have to just absorb that risk. Because remember, the seller remains in possession. The second approach is seen as more attractive because sellers are often the ones that still carry the property insurance, right? So remember, the second approach was the Massachusetts rule, and the seller bears the burden of risk until title is transferred. And that's attractive because sellers have to maintain their property insurance if they have a mortgage on the property. Most people have a mortgage on the property. And so under that property insurance, it would likely, the seller would likely be able to be reimbursed. Now, what is interesting about that is some homeowners policies, I think my homeowner's policy actually does not cover hail damage. So it wouldn't have actually have applied in this case anyway. That wouldn't have protected the seller. Apparently that was a separate add-on that you have to do. So the third approach we talked about, which is that the risk travels with the right to possess. It arguably takes on the benefits of the second approach and the first approach to an extent. So it takes the middle ground. It shifts the risk to the person that's entitled to possession. And arguably the person who possesses the property is the best party to absorb the risk because they can take measures to prevent the property being damaged during the period, right? So they can put storm windows on their property. There are things that they can do to protect it. We're now going to move on to the second question about risk shifting. And that is, what, if anything, must a seller disclose to a buyer before a sales transaction? What risk is the buyer taking on when they purchase a property? So this is commonly referred to as the duty to disclose. And there is a common law rule called caveat emptor, or buyer beware. And it says that the seller of real property has no duty to disclose defects to the buyer. So the buyer has complete responsibility to assess the condition of the premises and to try to determine if there are any defects. The seller under caveat emptor could be liable if, and only if, they A, made an affirmative misrepresentation about the condition of the property, or B, they actively concealed its defects, or C, they owed a fiduciary duty to the buyer. So A, affirmatively misrepresented the condition of the property. What does that mean? Well, if the seller lies or does something in order to misrepresent the condition of the property, then the buyer could not, even with a reasonable inspection, have discovered the defect. And so, at common law, there was an exception to caveat emptor if the seller affirmatively misrepresented the condition of the property. Same goes for actively concealing its defects, right? Owing a fiduciary duty to the buyer, then that means they have an obligation to act in the best interests of the buyer. That is what a fiduciary relationship is. So what might that mean? Well, what if the buyer is a client and the seller is that client's attorney, right? What if there is a fiduciary relationship there? Okay. All right. So we're going to now move on to a case, Stambovsky versus Ackley, which was pretty entertaining to read with all the puns. You could tell the court had a jolly good time writing this opinion. And the primary issue in this case is, when does a seller have a duty to disclose conditions affecting the premises? The facts of the case are a little bit, they're entertaining. This case takes place in New York. Stambovsky was a resident of New York City, and they entered into a contract to purchase a house owned by Ackley in a village called Nyack, New York. Anyway, before closing, Stambovsky discovered that the house was rumored to, or had the reputation of being possessed by ghosts. And that not only did it have this rumor was so pervasive that Ackley the seller had been able to monetize that. So she publicized her close encounters with the house's ghostly spirits in magazines like the Reader's Digest. And the house had a pretty widespread reputation for being haunted. So when Stambovsky realized that they were purchasing a haunted house, Stambovsky sued for rescission. And in his suit, he alleged that the reputation of the house impaired the value of the property and its potential for resale. So the New York Supreme Court dismissed the complaint, relying on caveat emptor. The appellate division reversed. And so this is the appellate division's decision. Now, before this case, New York courts pretty routinely apply the doctrine of caveat emptor to real estate transactions. Now, remember, caveat emptor says that the seller of of real property has no duty to disclose conditions affecting the property unless the seller misrepresents the facts, actively conceals them, or owes a fiduciary duty, right? So the seller had no general duty to disclose defects known to them and that were not readily observable to the buyer. Under this doctrine, had it have been applied, then Stambovsky would have lost, right? Because Ackley didn't misrepresent the fact that the house was haunted. She just didn't tell him that the house was, or that everybody thought the house was haunted. We won't get into a discussion about the court's statement that there is no material fact as to whether or not ghosts are real. The court had to decide if a seller is silent, so they didn't act or engage in conduct to deceive the purchaser. If the seller is just silent, did they have a duty to disclose conditions affecting the premises? Stambovsky, the court, only created an exception for caveat emptor with this case. And they call it a narrow exception to the doctrine. And they held on page 560 that where a condition which has been created by the seller materially impairs the value of the contract and is peculiarly within the knowledge of the seller or unlikely to be discoverable by a prudent purchaser exercising due care, non-disclosure constitutes a basis for rescission as a matter of equity. So the court really harped on the fact that Ackley had actively created a reputation for the house that it was haunted. So they said that she, quote, deliberately fostered the public belief that her home was possessed, and having undertaken to inform the public at large, to whom she has no legal relationship, about the supernatural occurrences on her property, she may be said to owe no less a duty to her contract vendee. So since the seller created and perpetuated the reputation of the house, the court felt that it would be unfair to allow her to benefit from omitting this key fact to the buyer. So if she's going to tell everybody else, then we should also hold that she should tell the buyer. So again, the court was a very narrow ruling. So the holding was a very narrow ruling. Stambovsky imposes an additional requirement on the majority test of caveat emptor, and that is if the seller creates the undisclosed condition and perpetuates it, then they may be required to disclose it. So what's the justification for this exception? Well, the Stambovsky court reasoned that to place the burden on the buyer to have to identify a condition that was almost impossible to find, as they put it, would encourage or at least allow for some predatory business practices, and it would be inequitable. So the seller is in the best position to know what defects the property has. The buyer can uncover some of these defects or many of these defects with an inspection. And so that is why the common law has placed the risk, the burden on the buyer to to inspect the property. But when the condition is such that the buyer, even with a thorough inspection of the property, would be unable to identify the condition, courts are less likely to apply the caveat emptor doctrine. Now for some disclosure hypotheticals. In the following hypotheticals, I would like you to determine if the seller has the duty to disclose under the majority approach, which is the caveat emptor, and then under the Stambovsky approach, which has that exception. Okay. Hypo number 1. S strongly suspects that the prior owner of his house uses lead paint when she repainted the living room, but S has never done any testing to confirm this suspicion. S knows that B has a 5-year-old son. Under the majority approach, does S have the duty to disclose? Under the majority approach, S has a duty to disclose if they know about the presence of the lead paint. There is a distinction between knowledge and strong suspicion, but in this case, there would probably be enough information for the court to find that the level of information was sufficient enough to equate knowledge to require disclosures. Now, the presence of lead paint wouldn't be easy to observe for the buyer. So now let's apply the Stambovsky test. Under the Stambovsky test, the seller wouldn't have a duty to disclose because they didn't create the condition. It was the prior owner that painted the living room, right? Or it was the prior owner that used the lead paint because the seller repainted the living room. So theoretically, they didn't put it there. Now, most states have laws so let's talk about quickly the modern rule. Now, each state requires sellers to disclose certain material information during a residential sale of real estate. It is in what's called the seller disclosures form. You may remember it from the real estate purchase agreement we went over early on, right? So most states would have in that disclosure, lead paint is one of the conditions that need to be disclosed. And those are statutory, typically. So each state will differ as to whether or not they would require disclosures in this situation. Next hypothetical. Seller knows that the electrical wiring in the house is old and brittle. 20 years ago, while S owned the house, there was a small fire caused by a frayed wire in a light switch, and B is an experienced electrician. Under the majority approach, S is obligated to disclose the condition of the wire because he knows about it. And it materially affects the value of the property. And it is also a condition that is not readily discoverable. It's not easy to see wiring that's hidden behind walls. You have to break the walls down in order to get to them. And even though the buyer is an experienced electrician, again, he would have to break down the walls in order to get and see that there were some issues with the wiring. What would the Stambovsky case say about this fact pattern? Well, if we apply the Stambovsky rule, the seller would only have the duty to disclose if he not only knew about the defect, but also if he actively participated in wiring the house. So if they did not participate in wiring the house, then they wouldn't have a duty. We don't have enough information here to make that determination. Hypothetical number 3. After the seller purchased the house, she accidentally discovered that it rests on a thin layer of rock perched over a vast cavern, which was produced by underground streams. A geologist advised her that it might fall into the cavern at any moment. There is no indication in the house or on the ground that the cavern exists, so B did not find it when he inspected it. Under the majority approach, does S have the duty to disclose? The answer is yes. S has the duty to disclose because S knows a material fact about the condition of the property, and that condition affects the desirability of the property. Also, that condition is not easily observable by B. Right? It would definitely lower the market value of your house if it's going to fall into a cavern. Now, what if we applied the Stambowski case? Well, because the seller did not actively participate in creating the condition, which is the cavern underneath the house or placing the house on top of the cavern, the Stambowski court would have found that he did not have the duty to disclose. All right, hypothetical number 4. The seller is selling a condominium unit to B. Seller knows that T, his former tenant, was raped while living in the unit, even though it has a state-of-the-art security system. The buyer informs the seller that she is buying the unit because 2 burglaries occurred at her prior house. Does the seller have a duty to disclose? Well, under the majority approach, the seller may have a duty to disclose. Now, because this is considered a psychological factor, state law will differ as to whether or not it needs to be disclosed. The reason, and there's a discussion about it in your book, is the evidence that psychological factors affect market values is unclear. Now, the modern trend is to move towards requiring disclosure of information in this case. And some states would require disclosure, but in other states, they had actually actively passed statutes that would protect the seller from liability for failing to disclose stigmatizing conditions, right, or psychological defects to the property. For example, somebody had been murdered there, committed suicide, or died of an infectious disease. So what if we applied Stambowski? Well, if we applied Stambowski, then the seller has no duty to disclose because the seller did not create the condition. They didn't burglarize the house. As far as we know, the seller did not engage in criminal conduct. So we have talked about whether or not a seller must disclose conditions on the property, but what about conditions that are off-site, that are not on the property, but are near enough that they might decrease the property value? And those were the facts in Strong v. Canuso. Strong v. Canuso is a case about an off-site landfill. So there was a landfill that operated as a hazard waste dump site from 1966 to 1978. And then eventually the toxic waste from that site contaminated local groundwater. The EPA warned in 1980 that building a housing development on land that was close by could result in some health conditions. Excuse me. But they didn't listen, and a housing development was built by the defendants. And years later, the residents began complaining about odors and physical symptoms that had to do with the gases from the the former hazardous waste dump site. So the plaintiffs filed a class action suit on behalf of 150 families that had purchased from this developer. And they claimed that the defendants who built or sold them the homes were either A, aware of the existence of the landfill and the hazards that it posed, but B, failed to disclose this information. Trial court granted summary judgment for the defendants. The appellate court reversed, and this is a New Jersey Supreme Court opinion, and they affirmed the appellate court's decision. In ruling for the plaintiffs, the court emphasized that one of the major persuasive facts in this case was that the defendants were professional sellers of residential housing and brokers that represented them, and that they, quote, had markedly superior access to information. And that because there was such a disparity between the knowledge of these professional sellers and the buyers, that equity required that such builder developers of residential real estate would have to disclose off-site physical conditions known and unknown to them that were not readily observable by the buyer if the existence affects the habitability, use, or enjoyment of the property and would render the property less desirable or valuable. So after this case, some state legislatures enacted statutes that limited the liability of these professional sellers. Sometimes they would be required to notify the buyers of these offsite conditions, and sometimes they would just have to direct them to a list of these conditions. I'd like to pose a question. Now, is the situation in Strawn similar to Fidelity Mutual Life Co. v. Kaminsky, where the landlord argued that his tenant could not assert constructive eviction when it resulted from the acts of a third party acting without the landlord's permission? Are there any distinguishing facts between the two? I'd like you to think about what the difference between the constructive eviction and the current case are. Well, one of the major differences is the relationship. So in one case, we have a lessor and a lessee, and in the other case, we have a seller and a buyer. Also, in Kaminsky, the landlord had the legal ability to control the third-party conduct on the premises, and they could there protect the interests of the tenant's use of office space. The seller in Strawn had no such ability to control the landfill, right? So, yes, these are distinguishing facts, but do they justify the difference? I don't know. It's for you to think about.